Who made those? Oh, I'm gonna nab one later. Okay. Oh, good. All right, we are back after a short break. Ms. Taylor is questioning the department panel. Sure. Are you recording? You are. All right. Go ahead, Ms. Taylor.
Thank you. I just want to understand the process, and then we can move on of the iterations in the drafting. So the public comment draft had a prohibition on surface water discharges, correct?
Correct.
And then you took public comments,
Correct.
and then the next draft was the December draft that was the petition to the commission for the rulemaking.
Correct.
And that version of the regulation added the possibility of discharge permits if water quality standards were set.
It implied such, yes.
And then you waited 2 months then to file an amended petition in March. And that amended petition removed the language that had the possibility of a permit, right?
Correct.
And it also removed the statements about setting water quality standards, correct?
Correct.
And then the last iteration of the rule was May 6th as a rebuttal exhibit, correct?
Correct.
And that added the NOI provisions about quantity and constituents for demonstration industrial projects, correct?
Correct.
And I think you testified that that was a crucial provision of the rule now, correct?
I'm uncertain that we use the word crucial, but
In your rebuttal on page 22, lines 16 through 18, Ms. Fulham, I believe you stated that this addition about concentrations and the quantity of produced water is, quote, crucial to the protection of human health and the environment under the state's Water Quality Act, unquote.
I will take your quote.
But you said it's crucial, but it wasn't crucial until this month, correct?
Incorrect.
So let's move on from the process of the rulemaking. And let's talk about New Mexico's need for water. And you have said, Ms. Fulton, I believe, in your direct testimony, that the state needs to expand its water portfolio so that potable water is not, quote, used for everything, unquote.
I believe so, yes.
And I believe you also said that climate change is anticipated to reduce the state's available water supply while water demand is increasing.
I recall that, yes.
And I think you have already testified at this hearing that, or this rulemaking, that 95 of the 407 active groundwater discharge permits authorize effluent reuse.
Correct.
And would you agree that produced water that is shown to be protective of New Mexico's surface waters could be reused to supplement water deliveries to Texas on the Pecos and the Rio Grande?
I can't speak to that
Why not?
because I have not been given evidence that it is protective.
But let's assume that it is protective.
I don't know that I can.
Well, just for the sake of my hypothetical, please assume that the discharge would be protective of surface waters. Okay.
I believe you're asking for an assumption that's not based on any evidence in the record right now.
Okay. And are you familiar with the permit that has been issued in Texas for discharge of treated produced water into surface water?
No,
Have you seen Mr. McCurdy's rebuttal testimony?
yes.
And he discusses or mentions that permit, correct?
I believe he mentions it, but I am not familiar with it.
So he has testified on a different topic that treated produced water can be treated to an ultra pure quality required for green hydrogen production. Required for green hydrogen production. Are you familiar with that?
I
generally?
recall reading that, yes.
Okay. And so if or when that's the case, under the proposed rule, no discharge permit could be issued for a green hydrogen project until a rulemaking is held to repeal the ban on the discharge of produced water. Correct?
If there was a discharge required, correct.
And so that could take years before the green hydrogen project could start, right?
If there was technology, that I would hope that we would petition the commission and get that in place.
But that process could take a few years.
Could, yes.
So I have another question. So let's say that the green hydrogen project uses treated produced water, but the treated produced water will not be discharged. Is that project then an industrial project? It's a closed loop system.
I'd like to clarify, closed loop is not necessarily non-discharging.
Okay, well, I'm sorry. Let me just rephrase that to say that it's non-discharge under the definition of 20.6.8.7 I3 or 13.
I'd like to pull up the
Sure.
definition for industrial project under the rule that we're currently proposing before the commission.
It's on NMED Exhibit 175 at 004573.
I have that.
Okay.
So as we have proposed in NMED Exhibit 175, industrial project means a reuse water project that does not discharge and that is used in connection with industrial processes such as alternative energy, hydrogen production, cooling water, process boiler feeds, utility power plants, chemical plants, and metal working facilities where at a minimum, public access is restricted or limited. So to answer your question regarding hydrogen production, that is part of the industrial project definition.
Thank you. And so that project then would be subject to the NOI requirements. Is that correct?
Correct.
And is that true even if the green hydrogen production process does not itself treat produced water, but only uses produced water?
Correct.
And that would, the beginning of that project or the initiation of that industrial project would not begin until they got an NOI determination, no discharge, correct?
Correct. Which at this point usually takes between 30 and 60 days.
Oh, thank you for that clarification. And I just want to just ask one more question about that supplementing the surface waters of the state of New Mexico with treated produced water. But if it is shown that it could be protective of surface and groundwater, then could it be used to supplement water deliveries to Texas?
I don't believe that the Environment Department oversees water rights or could speak to whether that could be supplemental to Texas.
Well, putting that aside though, I'm just talking about if the water could be shown to be protective of surface waters, could it receive a discharge permit to supplement surface waters?
Again, I believe that that's an assumption that the department can't make at this time.
Okay, so let's move on to the fact that, at least my understanding is that the NMED has never banned any particular source of water before.
Can you clarify what you mean by ban?
Sure. In the May 6th version of the rule before the commission now, the discharge of treated produced water is prohibited. And so I believe you've heard testimony and you have had testimony that you need this ban because there's a quote unquote loophole in the regulations that somehow, I think what you mean is that a treated produced water could be discharged if this rule is not put in place.
I believe that's my testimony specifically. And I do not believe that I stated that a discharge permit would be issued, but I stated that we would have to grapple with drafting a discharge permit, which at some point.
Producer Shelby Joe and director Kayla Hoffman are live to talk about delivering the motherload of big screen comedies.
I wish I could rely upon that answer. I'm gonna get my. Can we start over?
Sure.
Can you restate?
Oh, can I start over?
Yes.
Sure. As I understand it, the loophole issue that you have identified is that unless you have this regulation as proposed, that you could be forced to issue a discharge permit for treated produced water.
Okay, thank you. I believe my testimony stated that we would have to grapple with drafting a discharge permit. Issuance is where we kind of get in trouble with the framing of your question. It's not my determination as to whether or not a permit is issued. It would go through a public notice process. And then, but I do agree that we would, as the Groundwater Quality Bureau Pollution Prevention Section, be required to process an application through the public notice process and then work through the drafting process.
And I think you've said that allowing discharge, no, I'm sorry. And some other source waters for permitted discharge contain organic and inorganic metals, materials, salts, metals, oil, volatile and semi-volatile organic compounds, naturally occurring radioactive materials or norms, PFAS, and or chemical additives used in industrial or other processes. Correct? I believe that was Dr. Hu.
Yes, I have this statement in my testimony.
In some other source waters for currently permitted surface water discharges contain or may contain emerging contaminants. In some treated discharge water contain or may contain emerging contaminants. Correct?
Can you clarify whose testimony that was in again?
Let me see.
Thank you.
I believe that was Ms. Kamat.
Can you give me a reference, please?
You know what? I cannot at this point. So I apologize.
Mhm.
So, Ms. Kamat, how many NPDES permits have been issued in New Mexico?
Can you clarify on a time frame, please?
Sure. Last 3 years.
So EPA has around 90 to 100 individual permits issued in the state of New Mexico and 5 general permits issued in the state of New Mexico.
And as you just mentioned, they're issued by EPA, but the department must certify in the Section 401 certification process that they comply with New Mexico's surface water quality standards.
Correct.
And also, new surface water discharges undergo an anti-degradation analysis by the department before they're approved, correct?
Correct. All new discharges have to undergo an anti-degradation process before EPA will issue a draft permit.
And based on that analysis in its Section 401 certification, the department can set effluent limits for a discharge.
Correct.
And has the department ever denied Section 401 certification solely based on the source of the discharge?
To my knowledge, no.
And so you contend that there is a loophole in the Section 401 certification process that must be closed because the department cannot deny certification based solely on the source of the water.
Correct.
But NMED is not required to certify discharges of treated produced water, correct?
Can you rephrase the question or restate the question, please?
Sure. NMED is not required right now to certify discharges of treated produced water.
Correct.
And NMED can deny certification if the treated water fails to meet New Mexico's water quality standards, just like any other treated discharge, correct?
Can you repeat the question, please?
Sure. NMED can deny certification if the treated produced water fails to meet New Mexico's water quality standards, just like any other treated discharge.
Correct.
And that applies whether the other treated discharge is from industrial processes or wastewater treatment plants. Correct?
Correct.
So really there's no loophole to be closed, is there?
The loophole is that we do not have water quality standards right now to address treated produced water. And so having the prohibition will provide us a regulatory standing in a 401 certification denial.
So you're saying the department wants the authority to deny certification without doing really its job to confirm that the water does or does not meet applicable water quality standards.
No, what I'm saying is that there are unknown chemicals in treated produced water that we may not have standards for. And while we do have the anti-degradation process, if a constituent is not in the anti-degradation, we may not be able to protect the receiving waters. And so we want the ability to deny 401 certification.
And that's based on the fact that there are unknown constituents in the wastewater?
It's based on the fact that we don't have a complete characterization of produced water to perform a complete anti-degradation analysis based on the water quality standards. Water quality standards? Right.
But you don't have a complete characterization of municipal wastewater either, do you?
We have a much better understanding of the pollutants that are in municipal wastewater?
but not a complete understanding.
No, not complete.
And you don't have a complete understanding of industrial discharges either, do you?
We do not know everything that is in an industrial discharge, but in industrial discharges, we tend to know the process and what's gone in.
But you issue discharges permits for those types of waters, don't you?
We issue 401 certifications for those types of water.
I'm sorry. Yes, you were correct. It's a 401 certification. But so it's really because of the fact that it's treated produced water, you want to say, we're not going to issue any 401 certifications.
Correct.
But you have that authority already, don't you?
We do have that authority because the department has not denied a permit, denied a 401 certification. We need to have supporting evidence in the 401 certifications. So, for example, if a 401 certification conditions a permit, I have to have something in 20.6.4, 20.6.2, or any other regulation. And to deny a permit, I would need the same regulatory basis.
So let's move to a slightly different question. So let's say that a potential discharger of treated produced water recycles the produced water and learns from its customers the constituents of everything that went into that produced water, knows the frac chemicals, all the other things, and has the information on the source water. And then the recycler then designs a treatment train technology or technologies to treat those specific constituents and has pre-treatment and post-treatment. And then therefore the recycler can analyze the recycler can analyze the untreated produced water to determine the constituents in the feedstock and the treated produced water. They know the whole process. The results show that the treated produced water reliably meets the New Mexico drinking water standards.
What is the question?
I'm getting to that.
Okay.
But for the ban or the prohibition on discharge of treated produced water, why can't that water be permitted for discharge?
Are you asking specific for surface water or for groundwater or for both?
Let's take them one at a time.
Okay.
Surface water, since you're on.
So for surface water, the reason we would not issue a 401 certification is meeting drinking water standards is not meeting surface water quality standards. They are different standards.
Well, let's change my hypothetical to say that they meet all the water quality standards. Why couldn't you issue a surface water discharge permit?
If I may, for both.
Sure.
I've reviewed the record of the 1973 hearing where the original 3103 standards were promulgated, and those standards in that regulation were specifically promulgated and excluded oil and gas waste in their considerations. They only considered domestic and industrial wastewaters. And so those numbers, the numerical standards, as well as the future toxic pollutants narrative standard, were not drafted, argued, and promulgated specifically. They were specifically promulgated and excluded oil and gas waste from their analysis during that promulgation.
I can't do math. So that's a 50-year-old ruling proceeding before the commission.
Sure. I'm sorry. I've also reviewed the 1982 toxic pollutants, where they made the same exclusion, as well as the revisions that occurred after the Supreme Court of New Mexico argued and upheld portions of the toxic pollutants that were then returned to WQCC for revision. And there was also revisions in 1992, which I have not reviewed as extensively, but do also include the same caveats, I believe.
So you're just relying on the history of the regulations.
I'm saying that the numbers that we have and the standards that you're asking about their applicability here were specifically promulgated and analyzed to exclude oil and gas waste.
But what if all of the pollutants were removed? What if I ended up with a distilled water process that is oxygen and hydrogen? And could I not get a permit for that?
I can answer to that.
Sure.
We would have considerable reservations for discharging distilled water based on the removal of all the minerals in there. It makes it a highly aggressive water and it leaches out. So it would actually cause a problem as well.
And I just want to add that issuing a discharge permit doesn't just consider the water quality, it considers the reliability, it considers the permittees or the applicant's ability to maintain that water quality over long term. It considers what level of monitoring is required in order to ensure that happens. And we do not have that additional information at this time in order to write those types of regulations for these processes.
Write regulations or write permits?
Both.
Just one more addition to my hypothetical. Let's say I don't have distilled water that the process ends up with, but just purified water. Still has the minerals, still has good stuff, tastes good. Why couldn't a permit be issued for that?
Again, I would like to refrain from trying to project into the future. Based on the information that was available to NMED, we've developed the petitioned rule to be protective of ground and surface water.
This is a different topic. Do all surface and groundwater discharges permitted by the department result from anthropogenic activity?
So specific to the MPDS permits and the 401 certification, MPDS covers stormwater discharges. Stormwater discharges do not necessarily result from anthropogenic activities.
Other than stormwater discharges, do the other surface water discharges result from anthropogenic activity for surface water?
It's a big question with some nuanced complexity to it. I can say generally the vast majority, if not a very high percentage in the plus 90%, if not plus 95%, yes, anthropogenic.
Thank you. So we've talked about surface water permits. Let's move to groundwater permits. So roughly in the last 3 to 5 years, how many groundwater discharge permits have been issued in New Mexico?
I don't believe that's in my testimony, but I am the section manager and I will speak for the pollution prevention section, which issues industrial and domestic wastewater as well as reuse permits currently. We have 463 active permits currently that rotate on a 5-year basis. And so we, on average, will permit issue around 90 to 100 permits, mostly renewals, some new, many modifications.
And
year.
has,
Sorry,
excuse me, sorry, did you finish?
per year,
Can you just condense that and give that to me in a sentence?
about 100 per year.
Thank you. Has the department ever denied a groundwater discharge permit application on the sole basis of the source of the discharge?
No, not that I am aware of.
And that's because the department looks at the water quality of the discharge itself to ensure it meets groundwater standards, correct?
Amongst other things.
among other things?
Yes.
Is whether it meets groundwater standards the primary criteria?
I'd like to answer this as the reuse team lead and have Mr. Herman in the more general sense. For reuse water, when we permit reuse water, it is critical. Oh, that's okay. I will try. Um, I will speak as the reuse team lead and then refer to Mr. Herman in a more general sense for permits. When when applications for the discharge of reuse come in, the department does review and has to review the source water to ensure that there's sufficient treatment so that the water quality. So when we review wastewater treatment plants, they come in with plans and specs that say that they can remove, and we have to ensure that we have to know the source in order to know what type of treatment, to know what kind of effluent quality they will consistently meet. And for reuse, that is critical.
And I was asking more generally about groundwater permits. Generally, does that apply also to permits generally, looking at the source to know how the treatment is successful in meeting water quality standards?
Generally, that is one of the aspects that would be looking at. You mentioned a couple of the others, the treatment process, as well as, yes, but I would say that there's multiple primary things that we look at.
But it remains, I think we have said that you've never denied a discharge permit based solely on the source. Correct.
So I think I'll take this in the direction that I'm comfortable with, because I'm not aware of the full history of every permit. There's 2 other sections that issue permits. So I feel a little uncomfortable wading into that pool. But I will say that the Water Quality Act does set out the exact provisions that we have the authority to deny a permit under. And source water is not one of those.
Yes, sir. That anticipates my next question, that no existing regulation authorized the department to deny a discharge permit on the basis of the source or type of the water being discharged.
Yes.
And again, so there's no loophole to be closed. The department simply wishes for the first time to deny a discharge application based solely on the source water, even if the discharge meets existing surface or groundwater standards, correct?
I would disagree with that statement,
What part?
that there is not a loophole.
You believe there is?
Yes.
So what you're saying is that you want, excuse me. So what you're saying is you want separate standards for treated produced water based solely on the source of the water and not the quality of the treated water.
Can you repeat the question? I think I understand it, but I'd like to better understand it.
So what you're saying is you want separate standards for treated produced water based solely on the source of the water and not the quality of the treated water.
So we've shifted to a different phrasing, which then actually moves us out of what I was testifying to earlier, or my response earlier. We do have provisions in our regulations that are specific to types of discharge. We have domestic wastewater discharge requirements, industrial wastewater discharge requirements that must be met in order for us to, in order for the secretary to approve or issue a discharge permit. And so, no, I'm not asking for something special here. I'm asking for the tools necessary in order to accomplish the same type of process that is codified already in 20.6.2 for domestic and industrial waste discharges, in this case for untreated or for treated produced water.
I think you've also testified, Mr. Herman, that the department agrees that it's unclear whether the Water Quality Act authorizes the prohibition of the use of a specific water type when the use does not threaten ground or surface water.
It sounds like me, but if you could provide me with a citation to agree.
It was in your rebuttal at page 15, lines 12 through 14, and page 16 at lines 7 through 9.
Was that a quote?
It's certainly a close paraphrase of the quote. Yes, sir.
I'm sorry, what page again?
So page 5, your rebuttal, page 15, lines 12 through 14, and page 16, lines 7 through 9.
Okay, so it looks like it's my response. First, it is unclear if the suggested changes are authorized by the Water Quality Act and if the department can prohibit a single application of a specific water type when that specific use does not threaten ground or surface waters. That's the language. I'm sorry, what was the question associated with that language?
I wanted to make sure that's what you had said.
Yes.
And so my question is to follow. If the Water Quality Act does not authorize a prohibition of discharges based on source, then what authority does the commission have to adopt this rule?
I would likely look to the Produced Water Act.
Yeah, I'm going to object. That calls for a legal conclusion.
Right. Ms. Taylor, we're walking the usual line.
All right, so let's move to a different topic. And I want to understand for produced water demonstration projects and industrial projects and the rule as it relates to groundwater and surface water. There's a difference in how the May 6 rule treats surface water and groundwater in demonstration projects and industrial projects. So could you confirm that any produced water demonstration project or industrial project authorized by the department under the proposed water reuse rule will not discharge in a manner that may directly or indirectly affect ground or surface water and will not pose any risk to water quality? I think Dr. Hu spoke to that as well as Ms. Kalmat. Ms. Kalmat?
Can you provide the citation for Dr. Who?
Yes, I can. For Dr. Hu, it was rebuttal at page 3, lines 4 through 6, and Kalmat rebuttal at 13, lines 14 through 17. The language is that the rule, quote, provides a very narrow path for the safe use of produced water for limited, highly controlled situations for research purposes.
I found the citation. Could you please repeat the question for me?
I just wanted to confirm that that's what your testimony says.
Yes.
So if there is no discharge from these projects, then the WQCC has no jurisdiction to ban them, correct?
No, the Water Quality Act specifically states that any rule or regulation may include a prohibition on discharge if necessary.
But I think the Water Quality Act and Produced Water Act also says that the commission has no authority to regulate activities that do not threaten ground or surface water proposed rule and the proposed rule authorizes limited, controlled, safe, closed loop industrial projects.
I believe the Water Quality Act says that in order to be protective, that prohibition may be necessary.
So such water demonstration projects are important for the development of new or improved technologies to clean up produced water to levels that would allow the reuse of treated produced water outside the oil and gas field to supplement the state's water supplies, correct?
I think I got lost on the on-ramp. Can you restate that one?
I'll break it down. Are demonstration projects important to allow the development of new technologies to treat produced water?
I believe they can be.
And the authorization for non-discharging demonstration projects or industrial projects is contained in the discharge to groundwater subsection, which is 20.6.8.400A4.
Did you say authorization?
Yes, ma'am. That was in Ms. Kamat's rebuttal
Yes.
at 13.3.16.
Correct.
And so the proposed rule filed with the December 27th petition said in that section that demonstration projects and industrial projects, the proposed rule filed with the December 27th petition said in the section concerning treated produced water discharges to surface water, demonstration project and industrial applications related to surface waters submitted to the department through the notice of intent process are authorized to operate following the determination of no discharge permit required by the department. Is that correct?
I guess, may I ask some clarifying question?
Sure.
So the department proposed the May 6th revision of the rule, and the iterations of back and forth have been getting a little bit confusing because that's not what the department's petitioning for. So I guess maybe if you could phrase that in a way that's relative to the May 6th version, that would be helpful for
Sure.
us.
Let me just get to the point here.
Okay.
So the amended petition filed March 20th that, and this part has not changed in the May 6th rule. Remove the language in subsection A2 concerning treated produced water discharge to surface water while retaining it in subsection A4 concerning treated produced water discharge to groundwater.
Right.
That's the difference I'm asking about.
That's helpful.
Sorry.
So here's my ultimate question. Are the demonstration projects and industrial projects restricted to research related to the ultimate discharge of produced water to groundwater?
We're both trying to answer no.
I think we're both going to say no.
Okay. And so I accept your answer as no, meaning that demonstration projects could ultimately show the way to allow a discharge to surface water.
Absolutely.
Okay.
Correct.
Given that background or that sort of understanding of the intent, isn't the proposed language confusing because it only refers to demonstration projects regarding groundwater and not surface water?
Sorry, we had the wrong version up and I was
I get that a lot.
I'm gonna give you a point. I do see how that could be confusing. the intention of the department was not to restrict demonstration projects to simply final disposition in groundwater. It was to allow for demonstration projects that are researching or looking at any manner of items. I would point that an industrial project would not involve surface water. Correct. But I don't know that's really a valuable clarification here.
Are you saying you got something right?
Yes.
Okay, let's make sure that gets on the record. Well, would you agree then that the language needs to be added back into the surface water discharge section?
I would argue that that's speaking to the future, and at this point, I think that the rule as we've proposed still stands.
Even though it's confusing, you don't want to change it or propose to the commission that they
It's
do?
assuming that it will go to surface water at some point in the future. So demonstration projects really at this point are focused on groundwater impacts. So I think adding language to the surface water aspect, and I will let Miss Lucas come up to speak to that.
And so to add to what Ms. Fulham said, it's not a future prohibition. Like it could be, well, it's that right now none of the demonstration projects have any surface water component for reuse. Yes, it
I think we would just simply state that we support the language as written and that we don't believe that the clarification is warranted.
So I'm not right?
I apologize.
Well, I mean, I think you said earlier that language is confusing.
I believe I said that it could be construed as confusing or interpreted as confusing, yes.
What's the basis for that distinction between ground and surface water?
Can you be more specific? The distinction in 1, 2, 3, and 4?
The distinction.
Let's
So demonstration projects are in the rule now are looking toward groundwater, ultimate groundwater discharges. Demonstrations projects addressing surface water don't have the same language.
I think your question is couched in the idea that you're wrong, but I still think you're partially right. That, and I'll give you the reason it really is in the groundwater portion is a historical reason. If you look at the notice of intent process in 20.6.2, notices of intent are submitted to the Groundwater Quality Bureau chief, and the Groundwater Quality Bureau is the main processor of discharge permit notices of intent. And so we had something going there that we liked and carried that over into this process as well.
I'm sorry, could you just repeat that last part? I just couldn't hear it.
We were used to the process that exists in 20.6.2, and so we mirrored that in the proposed regulation.
So one more topic, and then we all get to go to lunch. Time flies when you're having fun, right?
Yes, it does.
So economic costs. Would the department agree that economic benefits or costs are not a relevant consideration when determining whether a discharge permit should be issued? Mr. Herman, I think you have testified to that.
Yes. Yes.
So you would agree with that statement that benefits or costs are not relevant in issuing a discharge permit?
I would like, if you have a citation, to understand the context that I testified to that within.
Sure. It was your rebuttal at page 14, line 21, 22. And I think a paraphrase of that quote is that the department rarely considers economic benefits or costs to be a valid evaluation tool.
So yeah, the modifier that's important there is rarely. I believe that we do at times consider it, but it is not common.
Thank you. That concludes my cross-examination.
Thank you, Ms. Taylor. We still have a little bit of time before we'll break for lunch. Mr. Cox, do you have questions of the department panel?
I do, Madam Hearing Examiner, just a few.
Thank you.
Just a moment here. This is just for the panel generally. In the proposed rules, is there any limit to the size of an industrial project?
I can answer that. No.
Thank you. And I'm just gonna ask a few questions about notice. Not the notice of this rulemaking, but the notice related to the NOIs. For the notice of intent process, is any public notice required?
As written, the proposed regulations do not have any notice requirements associated with them.
Thank you. So the applicant's not required to publish anything in a local newspaper or anything like that if for a notice of intent for an industrial or demonstration project?
So in our regulations, the term applicant has a very specific meaning, and I would maybe prefer to say that someone submitting an produced water NOI is not required to do those things.
Okay. So hypothetically, if a company is going to build an industrial reuse project next to where I live, I'd have no notice of that. Is that correct?
Not as it pertains to the notice of intent for using produced water in a non-discharging manner.
Right. And I heard earlier, I believe you testified that currently the department is posting these NOIs to their webpage. Is that correct?
Yes,
And when does the department post the NOI relative to when they receive it?
probably within a couple days.
And so is it being posted, before it's approved or afterwards?
When the NOI is submitted, I post it. We review it, and there's when we issue the no discharge permit required letter, then that's posted.
Okay. So it's after the determination that no discharge is required, no discharge permit is required?
Can you say that again?
So I'm just trying to make sure I hear what you're saying, that it's you publish you post the NOI on your webpage after making the determination that no discharge permit is required. Is that correct?
No, it's a work in progress. When they submit an NOI, I put that on the web page. And then it's probably within 2 months of a review, and then we issue all applicable documents we put on the web page. So for example, if we require more information, I also post that.
Okay, thank you. But that's not posting. That posting is not required by the rules currently. Is that correct? The proposed rules?
That is correct.
And is there any public comment opportunity for notices of intent for industrial or demonstration projects?
No, there is not.
And is there any public hearing opportunity for notices of intent for industrial or demonstration projects?
No. The notice of intent process is designed for us to make a determination as to whether or not we would have regulatory authority over that project. So a hearing would have to be scoped in whether or not we had authority. The hearing would be held on whether or not we had authority over that activity.
All right.
I'm not supposed to, but I'm taking your question and running a hypothetical in my head.
Sure. No, I'm trying to, I just want to work through this, how this might work. If, so if a member of the public, let's say me, there's a industrial project going in next door. If I disagree with the department's, I don't want to say approval, because if I disagree with the department's issuance of a no discharge permit required in response to an NOI, is there any way for me to challenge that decision?
Absolutely. Our regulations have a provision that state any determination or decision made by the Secretary of the Environment may be appealed to the WQCC.
And how long do I have to file that appeal?
30 days.
And how will I know to file that appeal without a public notice?
I was going to make a snarky comment, but I'm not going to because this is serious and you would not.
Okay. So thank you. Yeah, I think that's.
Hold on. Kathleen Murphy has an addition to that.
Okay.
I believe in the NOI, it states that the neighbors need to be noticed.
Where does it state that?
One moment.
No, I'm sorry. That's in our attachment B in our current process.
So that's attachment B in the current process, but not in the proposed rules. Is that correct?
Correct.
And what does that notice look like currently in attachment B?
We're going to pull the exhibit up real quick so we can make sure we're accurate and correct with our response.
Sorry about that. Thank you for your patience. Currently, we do have demonstration projects as people have testified to so far, and they're required to, or we ask them to submit a notice of intent with additional information that's required in what we call attachment B. That can be found in NMOGA Exhibit 29, and it starts on page 11.
All right. But that's not required by the proposed rules, correct?
Correct.
Okay, thank you. I'd like to move on to my second and final topic. And I'd like to talk a little bit about the Canales project. And I believe Mr. Herman spoke about this issue a little bit on Tuesday, so my initial question is going to be directed at you, Mr. Herman, but again, I welcome answers from the panel. Mr. Herman, you stated that there was some concern that the Canales project had resulted in produced water being discharged. Is that correct?
So no, there's three aspects of the company Canales in all of the testimony and exhibits. There is an event that occurred prior to any project. There is the first pilot project, and there is the proposed second pilot project. The initial event, I think, is what you are referring to, that we went and inspected with the Oil Conservation Division.
Okay, so that's you're referring to that as the initial event.
Sure, I'd like that.
And there was a concern that there'd been some potential discharge as part of that initial event related to Canales. Is that correct?
It was reported. It was reported to us that a discharge of treated produced water had occurred.
Okay. And the question was whether the treated produced water had been applied to some grasses that were just on the ground. Is that correct?
Correct.
And you stated, I think on Tuesday, that some sampling was done in response to this concern?
The Oil Conservation Division did, yes, sampling, soil sampling.
And that, as a result of that sampling, you determined that treated produced water had not been discharged?
I did not make that determination. The Oil Conservation Division did.
And that sampling was conducted by Interra Geosciences and Engineering. Is that correct?
Yes.
I'd like to take a look at that report. I'm not sure the best way to share it since I'm remotely. I submitted it as Center Exhibit 7. I uploaded it to the Dropbox earlier today, but I also filed it on May 6th. Ms. Jones, what's the best way for us to talk about this?
We have it.
Screen?
We have it up on our screen.
Council, you can share your screen if you'd like. You're on the platform.
Okay. Yeah, but you also have it there, Mr. Herman?
And I mean, it's Center for Biological Diversity Exhibit 7.
Yes.
Yes.
Pam just made you a presenter, Mr. Cox, so you can share your screen.
Great, thank you. Is that showing up?
Yes, it is.
Okay. So I have too many PDFs open.
I think you're going to want to hit the plus sign, though. It's very hard to read.
Okay. Is that any better?
That is better. Thank you.
Great. Thank you. So, Mr. Herman, are you familiar with this report from Interra?
It has been a long time since I reviewed it, but yes.
And this is the sampling report for the soil at Canales. Is that correct?
Yes.
And regarding whether produced water was discharged at Canales, was any other sampling or analysis conducted beyond this report?
Not that I'm aware of.
Okay. So to your knowledge, this study is the sole basis of OCD's determination that treated produced water was not applied to soil at Canales.
I cannot speak to what OCD utilized in their determination.
Okay. But you're relying on OCD's determination.
I can only speak to NMED's determination that the activity occurred on or within the Oil Conservation Division's jurisdiction and not the Environment Department's jurisdiction.
Okay. But when you stated on Tuesday that treated produced water was not discharged, what were you relying on for that statement?
The communication from the Oil Conservation Division that was their determination.
Okay. I'd just like to take a look at this report. If we scroll down to the bottom of what's the second page, which would be marked Center 17, the Bates label, I've highlighted here on the screen. Maybe we can zoom in a little more. Oh, too much. So can you see that final paragraph on center 17 and the top of center 18, Mr. Herman?
Yes.
Could you read that for me, please?
These results relative to background levels suggest irrigation of the raised bed with a source other than untreated produced water. To identify the source of the water used for irrigation with some certainty, a comparison of geochemistry data produced from this investigation with data collected from potential irrigation water sources, coupled with an evaluation of data concerning the volumes and periods of application, are necessary. Data revealing the extent of filtration would be necessary to determine if the water used for irrigation derived from treated produced water.
Thank you. So would you agree that based on this report, they've determined that untreated produced water was not discharged, or was not applied to those beds? Is that accurate?
I believe that Intera is the author of this report, and that would be Intera's determination.
Yes, but you agreed that that's Intera's determination that untreated produced water was not discharged here?
Yes.
And that Intera doesn't know if treated produced water was discharged. Is that also correct reading of this paragraph?
Yes.
And to your knowledge, this is the report. This is the analysis that was done to determine whether produced water, treated or untreated, was discharged at Canales.
Yes.
And has OCD, in your conversations with them that you've based your testimony on Tuesday on, did they reveal that they had done, that they had more data revealing the extent of the filtration, or that they had, collected data from potential irrigation sources coupled with an evaluation of data concerning the volumes and periods of application?
The only recollection I have is they had conversations with the on-site manager as well as the on-site manager's son, I believe.
Okay. Well, thank you, Mr. Herman. I don't have any further questions. And that concludes my cross-examination.
Thank you very much, Mr. Cox. You can stop sharing then. We have just about 6 minutes. Is Mr. Hightower on the platform? I have reason to believe he's not. All right, he would be next in cross-examination. Mr. Davis, will you have cross-examination of the department panel? Can you just go for about 6 minutes? Thank you.
Good morning. I'm going to try to be not as loud as yesterday. Oh, you do? Okay. I can oblige. I'm going to go through just one quick topic and then stop and check in with you, Madam Hearing Officer. If you don't mind turning to NMED Exhibit 175, I believe that is the most current version of the proposed rule. Is that correct?
That is correct.
I'd specifically like to ask you about section 20.6.8.400B2.
Very specific. Thank you.
That section reads, no person shall cause or allow treated produced water to discharge. So, sorry, that's A2.
Got lost for a second.
Yep. The demonstration project or industrial project shall be designed to provide information specific to untreated produced water quality, treatment technologies, treated produced water quality, treatment volumes, and toxicity studies for potential produced water reuse applications. Did I read that correctly?
Yes.
Let's have a few questions about what parameters are required to be included for treated produced water quality. So the question is what parameters are required to be included for treated produced water quality under that provision?
Describe parameters, I guess, that can mean a lot in the scientific world.
Sure. Are there any standards that are required for treated produced water quality reporting under that provision?
There's nothing specified as far as the constituents, the particular constituents they would provide. The information that we would get or not get from this will be or will not be used to determine whether we can develop standards.
Who would decide what the standards are or what is reported?
There's two different questions there. What the
Sure, take
standards
one at a
are,
time. Yeah, who would decide what the standards are under that provision?
there are no standards.
Who would decide what is reported under that provision?
There is no reporting under this provision. It's part of the notice of intent at the initial.
Who would decide the design of
The entity,
being the project proponent?
correct.
Okay, thank you. Would this require the reporting or would this require any toxicity studies to be performed for a pilot project?
Does not require that.
Does it require an analysis of treatment volumes?
It does require in another section the volumes that they're proposing to use.
Does it require characterization of produced water samples for the project?
State that again.
Would this provision require characterization of the produced water sample?
It does say that it should be designed to provide information specific to untreated produced water quality. It doesn't prescribe what parameters would be in that water quality analysis.
And so those parameters would be decided by the project proponent.
Correct.
This is a good.
I would just like to add that we go through an iterative process with these submissions, and so the department would be a collaborator on that. We wouldn't assert authority over it generally, but we could, and we could make that a condition of a no discharge permit determination.
So I'm trying to think about how this would play out. The project proponent would submit a design plan. The department would then potentially give input on that.
It would come through the form of a request for additional information. I love my hypotheticals that I'm not supposed to give. We get an NOI that they say we are only going to characterize TDS, and we're going to run this project in this manner. The department would likely push back and say, we cannot make a determination based off of that limited amount of information.
Under your hypothetical, if the project proponent did not take the department's input into consideration, could the department deny the NOI request?
Under the proposed regulations, yes.
And what provision in the proposed regulation would permit that?
That would lead us to a discharge permit required determination, and therefore, I mean, yeah, I walked myself down this one, didn't I?
So if you don't mind, I'm just gonna elaborate a little bit on what Mr. Herman was saying. These notices of intent that get submitted are reviewed by the department personnel, and those are the personnel and the scientific staff that you have before you today. We do work with industry regularly on these demonstration projects. They have a need to try and learn the characterization, potential treatment options, and then what their effluent quality is. So although it may not necessarily be required under this regulation, it is something that we would work with them for, because the ultimate goal for industry is to learn whether they can or cannot treat produced water. And so to answer your question, it may not be specified or prescribed here, but it is in the best interest of the department and industry in order to get the information if they were to want standards to be adopted in the future. Hopefully that didn't look like it clarified it for you.
I think simply stated, my question is whether there's anything in the proposed rule that would allow the department to deny a notice of intent based on the design plan that we've been discussing since I began my questions
Yeah,
a few minutes ago.
So a denial would look identical to silence from the department. Silence. Sorry, that we would not issue a no discharge permit required, and there is a provision within the regulations that says that they may not go forward with the demonstration project until they have received a no discharge permit required determination from the department.
Is this a good place to stop, Mr. Davis?
Yes.
All right. Let's come back at 1 for public comment.